Welcome to Medmarc's webinar series. Today's presentation is titled Claims 2024, What's Happening and What You Need to Know. I'm Kate Klaus, Senior Risk Management Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, thank you for joining us. We're fortunate to be joined today by Medmarc's exceptional claims team, led by Sonia Valdes, Medmarc's Vice President of Claims. Sonia is joined by Andy Hall, Executive Claims Specialist for Medmarc, and Lauren Hulbert, Senior Claims Examiner and Administrative Supervisor with Medmarc. We also have with us today attorney Jeff Nicoson, a partner with Leitner Williams Dooley and Napolitan in Memphis. His practice focuses primarily on products liability defense, healthcare liability, insurance coverage and bad faith litigation, commercial litigation, personal injury defense, defense of governmental entities and governmental immunity claims, and toxic tort and environmental litigation. Jeff is a member of the Defense Research Institute and an active participant in the Defense of Government Action Sub-Litigation Group for the Drug and Medical Device Committee. He is a graduate of Taylor University, Ball State University, and the University of Louisville Brandeis School of Law. And with that, I am pleased to turn things over to Sonia.
Thank you, Elisa, and thank you, Kate. Our agenda is action-packed. It's very ambitious, and I think it's also very timely. We're going to spend a lot of time talking about supply chain management and some of the issues that we're encountering on the international side. And then we're going to switch over to probably the most seminal case we've had to deal with in the life sciences area in a while, the Loper Bright case. We will follow the years past seminar and talk about some of the big verdicts and then give you our predictions. I thank you for joining us and welcome to our year-end seminar. So I'm going to kick it off by talking about supply chain management. I had a case 20 years ago. It involved it was a terrible case involving a deceased child who died as a result of a defective ambu bag. An ambu bag is a manual bag that provides 100% oxygen to the recipient. This was defective and did not inflate, but gave a false reading that it was inflating. This particular ambu bag, the raw materials were sourced from Malaysia. The ambu bag itself was manufactured in China and assembled and packaged in Latin America for use in the United States. And I thought that was a crazy fact pattern 20 years ago. It's not. We are more and more a part of a global economy, and situations such as the ambu bag product are common. I mean, we source raw materials from countries, we bring them into countries that it's cheaper to manufacture in the United States, and now Latin America and South America becoming points of assembly and packaging for these products. One of the things that is kind of interesting too is that our international reliance has not kept up with FDA inspection of these goods. At present, the FDA only inspects about 6% of the products entering the US and about 15% of the manufacturing sites in the US. This has led to some problems. There have been historic widespread problems. I'm going to focus a little bit on China because that's where we're heading towards China and India because of the tariff situation. But I mean, we've had some huge losses, not least of which is heparin. Heparin is an anticoagulant. It was intentionally contaminated with over-sulfonated chondroitin, which spiked when you ran it on the gas chromatograph. It showed a higher level of potency of the drug when it really wasn't. But the manufacturer got more money from the customer for having a higher graded heparin. It caused a lot of injuries and a lot of deaths. Historically, we also had the menu pet foods, contaminated pet foods that killed a great many pets. You would now be challenged to go to a pet food store and find pet food that doesn't have a made in the USA because of the lingering effects of the menu pet food scandal. And lastly, the use of lead paint in children's toys. That was a disaster. But this is something that we've had to deal with in the past. And what's been the underlying cause of these? Lax regulatory environment in China and India, quality control issues, a lack of transparency. And then there's also contamination. It's such a need for these manufacturing facilities to turn out the products that we need, that they're not just manufacturing your product, They're manufacturing a wide range of products. I had a case not too long ago in which the particular manufacturing plant did a pesticide production and shifted gears into children's medicines. So, I mean, it is horrifying, but this does take place. And these challenges have not gone away over time. During COVID, there were international recalls in the United States and the Netherlands of PPE, personal protective equipment, mass diagnostic kits, and bring it even post-COVID, valsartan. There was a recall of at least 20 different types of valsartan, generic valsartan, which is a blood pressure medication that's very widely used. The valsartan was contaminated with a known human carcinogen, and you'll hear more from Jeff on this particular case. And private label manufacturing and CMO manufacturing in China continues to be challenging. If you really want to hear more about what's going on, there's a story about CVS, who does private labeling private labeling exclusively in China, and some of the challenges they have faced. And in keeping into 2024, lest you think that these are all in the past, 2024, there's been a widespread recall of syringes, and one of the coped inhalers that I use, leading to shortages in the US. But some of the new problems that we're dealing with, this is a hit reel of old problems. We've got new problems now. Deteriorating economic climate in China, particularly for manufacturing. Many Chinese manufacturing companies are having problems and facing bankruptcy. Why? They don't have the manpower or the labor to meet these contracts. Remember, China is mainly an agricultural society. They're bringing in the labor from these farms. Some want to work some don't. And so there have been many instances recently of Chinese companies withholding inventory and demanding higher payments from customers to release it. This is a step before they go into bankruptcy, so they just pocket the higher payments. It's getting a little challenging out there. So let's talk about the new considerations. The US and China are locked into verbal sparring, which may lead to an all-out trade war. With threats of tariffs and sanctions from the incoming administration, China has recently retaliated against the United States by banning for export to the US valuable hard metals such as gallium, germanium, and antimony. They claim that the risk that the United States will use them for military purposes. Gallium and germanium are used for semiconductors, but they're also used for thermometers and other life sciences uses. They are also threatening the Chinese, that is, to withhold the sale of metal, the graphite. Now, they're outside of China, there's very few producers of graphite. So this could be a huge problem. And here, let me give you an example of the theft of intellectual property and the risk that we're dealing with internally. The FBI has scrutinized and has investigated a company called GenScript. GenScript is in Nanking, China. It is a contract development and manufacturing organization, which includes services such as the production of custom gene synthesis for US companies and US government entities. This company, the risk is that this company could share intellectual properties from US biotechs and pharmaceutical companies with the Chinese government. And that is more apparent when you realize that the CEO of GenScript is also the Chinese Communist Party committee secretary. So this is one that the FBI has had on their radar. One of the things we're seeing now too is forced technology transfer to break into the market in China. What is forced technology transfer? It's extortion, plain and simple. To get a foothold in a foreign market, you are required to share your technologies in exchange for market access. It can be this forced technology transfer can be accomplished a number of ways. One of the simplest is requiring a domestic firm to partner through a joint venture and sharing your technology with the domestic firm. Another way that this forced technology transfer is being put out is through regulatory proceedings. Foreign companies are required to disclose their technology to host company regulators who then share this technology with domestic firms. Licensing procedures have become more and more explicit, and to be licensed procedure calls for sharing and disclosure of sensitive information. And then lastly, if all else fails, there's always cyber intrusion and cyber theft. Another way that we've seen the the theft of intellectual property is through bad faith trademark registrations. That refers to the act of intentionally filing a trademark application with the dishonest goal of taking advantage of another's established trademark or reputation by registering a confusingly similar trademark and therefore tricking the customer into thinking they bought the original brand and not the secondary brand. And then there's always counterfeiting. Counterfeiting continues to be a problem. The counterfeiting is now spread into drugs and devices. There are many examples of fake COVID vaccines that were a little more than water that were distributed to Africa. Similar fake malaria vaccines in Angola. And there have been instances recently where there have been counterfeit J&J contact lenses and surgical sutures. And even more problematic during the pandemic, over 50% of the over 50% of the products in the PPE space were counterfeited, and they were traced back to China. So key takeaways. So what can we expect from these tensions? Shortages of component parts, raw materials used in medical devices and drugs and medical devices, continued lack of cooperation from the Chinese government in litigation involving their companies, and there is no other, I mean, I'm going to jump a little bit. Many of these products cannot be manufactured outside of China and India because of the raw materials aspect of it. So let me shift gears a little bit too. Now we're going to be talking the next couple of slides about China, clinical trials. And I'll be switching gears to India first because there's a number of international clinical trials that are taking place in India. Again, very cost effective. There are similar issues with the companies, and it's just the demand is so high and there are so few people that are adequately trained to run these clinical trials. The data suffers. There are issues with unethical conduct, lax laws and regulations, little to no IRB involvement, and little in terms of the accreditation process. There have been a number of controversial clinical trials on mentally challenged patients who obviously cannot consent. There was a lot of publicity about that in China. Patient recruitment continues to be a challenge. Getting the right participant is a problem. Informed consent. Many of the participants in both countries tend to be unsophisticated and uneducated, and it is very difficult to adequately convey the risks. But because these costs are still favorable, the costs of many companies clamoring for their trials in these two countries, there's just simply not enough personnel to do this correctly. Next slide, please. So there are unique problems associated with clinical trials in China. There is a record-breaking number of clinical trial registrations in China in 2023. That number reached 4,300 registered clinical trials. That's a 26.1% increase, surge in the number of clinical trials year over year. The consistent 5-year growth trend with it's a consistent 5-year growth trend with an average of 16% growth annually. Small molecule drugs continue to be the primary focus, making up 76% of the new trial registrations, while biologics compose 22.2% of the new trial registration. Similar challenges to India. There is also rampant data fraud in China and involving the informed consent. There are similar problems with the problems in India. But there is a unique problem in China, and that is the Chinese Communist Party's 5-year plan for global pharma dominance. It's an actual work that they've put out. The Chinese Communist Party's plan involves both the development and acquisition of technology to become a global pharma leader. Their acquisition may involve the theft of intellectual properties by Chinese government oversight of private clinical trials. The Chinese government has now become very involved in these clinical trials for alleged safety reasons, which may be purely theft reasons. To be sure, these concerns have been building. In 2021, the U.S. House of Representatives put together the draft BioAssure Act, which would have limited United States companies from doing business with Chinese biotech contracting companies. The act would have required U.S. companies to cut ties with certain Chinese companies on the blacklist created by the U.S. Defense Department by 2032. Another goal would have been to safeguard American health and genetic information from foreign adversaries, while forcing the United States companies to reduce their dependence on China. Unfortunately, just a couple of days ago, the Biosecure Act was written out of a defense appropriations bill in a major win for the Chinese medical industry. I'm going to hand it off to Lauren, who's going to explore other different aspects of this situation.
Thank you, Sonia. So like Sonia was talking about, there are and there have been some changes with how life science companies have been able to do business with China, India, and other foreign entities. And as a result, life sciences companies have continuously had to adjust, given all of these outside influences that affect their business as usual. And for many, the restrictions that you see here affects component parts and require these companies then to go out and find new source materials. For some of the metals that are noted here, China, it produces 40 to 50% of that product and of that natural resource. And so going somewhere else puts a big impact on these companies. So in addition to this, we have the new administration that's coming along, and President-elect Trump has already come through to say that he's going to increase a 25% tariff on goods from Canada and Mexico, as well as an additional 10% increase on goods from China. And these things are in the name of trying to address the drug trades that's coming along. But the ultimate effect of these increased prices is going to then affect the manufacturing capabilities and the cost to consumers ultimately for these goods. And then these new tariffs are in addition to the ones that were instituted in 2018 during President Trump's first term in office, when he put tariffs on steel and aluminum, which also affect our industry. So these things are definitely going to affect sourcing for these companies, which is going to affect increased pricing and ultimately, the end consumer and users. So the question then is, well, what do we do? What can we do about it? With the use of AI and different materials and technology, Andy, can you flip the slide? There is an understanding or a belief that companies can constantly review and audit their supply chains, so that, machines are doing this instead of people. And when you look at the companies that are within your chains, you really do have to look at what their missions are, who they are, who are their vendors. You really have to go through the entire relationships to see kind of who you're doing business with and what do they do, how do they do it, what does it mean. You also have to look at kind of their structure and their workloads, and does it align with what yours is? Because as a life science company in the United States, it's your brand if something goes wrong. The FDA can come to you, and then you will then have to go theoretically against those sub-suppliers for any kinds of issues that arise. So then the question is, what kind of contracts do you have in place with these companies? Are they current? Are they enforceable? We've run across that, I don't know how many times over the years, where the contract is from the 1990s and it doesn't quite do what you think it does. It doesn't have insurance requirements. It doesn't have quality requirements. It doesn't allow the company to go in and audit to ensure that the processes and the products that are in place are living up to what was originally contracted. So in addition to all of those things, you also have to then step back and not just look at the companies that you're interacting with, but also the environment that they're looking into. And that's kind of what those online research tools are at the bottom of the screen. It kind of gives an indication as to the different countries that do business with the US and kind of what their financial status is, what the financial environments are, because those things also can impact your vendors and how they do business, and then how they can service you, so that you can, have a quality products. Okay, so that would be, and then so after this, so those are kind of things that we're, to think about. And again, it's continuous, right? It's using AI, using technology, leveraging technology where you can, because it's hard for small companies to then take time to figure out and to go behind somebody to verify that they're doing exactly what they're supposed to be doing all the time. So now we're going to turn it over to Jeff to talk about Loper Bright.
Thank you very much, Lauren. Loper Bright is probably one of the most hotly anticipated cases of the past term. And in some respects, it was 80 years in the making. Just for some quick history, there's been about an 80-year history involving some levels of deference by the courts to federal agencies, and that started with the Skidmore case in 1944, which allowed the courts to give deference to persuasive arguments from agencies on the interpretations of provisions. And then in 1946, the Administrative Procedures Act arrived through Congress, and Section 706, which plays very heavily in Loper Bright, basically says the reviewing court decides all relevant questions of law and interprets constitutional and statutory provisions, as well as the meaning and applicability of those. From 1946 to 1984, that kind of held sway until the Chevron case was decided, and that produced a sea change with regards to interpretations of ambiguous or silent statutes if the specific issue was not mentioned within the provision. Under the Chevron analysis, if the issue was addressed and it was clear, then the court made the decision and that was the end of it. But the big problem that arose from Chevron was the second part. We're trying, if the statute was silent on the issue or ambiguous on it, essentially what happened was that the court would give deference to the agency interpretation if based on permissible construction, but that deference would include if there was inconsistent decisions or changes over time, the deference had to continue. So from 1984 for the next 40 years or so, the courts have continued to weigh this quite heavily. They were faced with binding deference to agency interpretations, even if those were inconsistent. This resulted in many times that the matter went back to the Supreme Court in order for some clarification. There was inconsistent applications by lower courts of this. And in fact, the Supreme Court itself stopped relying on Chevron in 2016 and even noted that in the Loper Bright decision. Loper Bright, and we'll talk about the facts a little bit here shortly, but the upshot of the case was the issue was very simple. Should Chevron be overturned? And the court decided that it should be. Loper Bright is actually a conglomeration of two specific cases that were combined. You'll see in the news reports that it was reported as being 6-3 or 6-2. There was actually a 6-3 and a 6-2 verdict decision. One of the cases, Justice Jackson did not participate, thus the 6-2. But the 6-justice majority said that basically that Chevron is overruled. The Administrative Procedures Act requires courts to independently adjudicate the statutory language and come to their decisions themselves, and they may not defer to the agency interpretations on the ambiguous law provisions. They relied very heavily on the APA, the 6-member majority did. They also relied very heavily on Article 3 authority, going back from Marbury versus Madison, saying that the courts are the ones who decide and say what the law is. And there was further discussion with regards to stare decisis and pointing out some of the history I already pointed out previously, which was the inconsistencies over time, the inconsistent applications, and eventually, as the Supreme Court noted, it stopped following along. So where does that leave us today? If we move to the next slide, please. Loper Bright is not over. The case was actually based on commercial fishing fees. The act in question, I won't try to say it's very lengthy, but it involved a requirement that to have observers on board fishing vessels to observe for conservation purposes the fishing grounds and the fishing that was being performed. The litigants in this case were Atlantic herring fishermen. The agency in question was saying that they had to pay the fees for the observer to be on their vessel. So not only did they have to put an extra person on their ship, but they had to pay for this person to be there. The fishermen understandably disagreed with this. but the statute in question was silent on it, but the agency was taking the view that they did have to pay for it. That's the legal challenge. Pre-Loper Bright, Commerce Department's view is what held sway. But now this case was kicked back down to the DC Circuit Court of Appeals, where it is being litigated. Back in early November, the 3-judge panel had about a 2-hour argument. There's been some reporting on that, and at the bottom of the slides, you'll see some links to some articles which detail this. And the judges at that were trying to find ways to compare the program to the others' programs, to find some analogs where they could say, well, what's the actual intent of this Fisheries Act that we're talking about here? And they begin to weigh very heavily how to assess the congressional intent from the statutory language, which is intentionally what the majority in the Supreme Court wanted them to do, is to actually perform legal analysis. And they spent 2 hours trying to discuss that with the various sides of what is the way to do that. Well, now we have a new paradigm, and in the next slide, we'll kind of talk about some of those new paradigms we're dealing with. This obviously, for lack of a better phrase, has produced a sea change in the law. And where does that leave us now? If you start looking through news articles, you can see there's many challenges coming with Loper Bright being used for it. In fact, before we started, Sonia even noted one with regards to criminal statutes, and we even located a case just to show how far this is already reaching, where somebody is using it to challenge deference to the federal sentencing guidelines in criminal cases. So they're not limiting it to simply the types of cases we litigate, but it's going to have a very broad impact. But looking at that, are there actually any limitations to what Loper Bright can do with regards to agency deference or other actions that we see in our practices? And the answer to that is actually yes. First and foremost, Loper Bright made clear that if the statutory language is clear, the courts interpret it, and that remains their core judicial function. But if you look to agency policy making or agency fact finding, which are functions generally committed to those executive agencies, deferential standards remain in review for those actions. And they have their core discretionary functions available in order to do the things they have been doing. Some examples would be FTCA decisions involving prescription medical product marketing or product labeling that the FDA controls. In addition, other forms of deference that have been on the books for a while will also remain. I mentioned the Skidmore deference earlier. That again allows the court to weigh the agency's interpretation based on their expertise and to give not exactly deference, but to consider persuasive in making their decision. That remains good law. In fact, it was cited favorably in Loper Bright. Another form of deference that you all may run into is the Auer deference, if I said that correctly, where the courts will defer to the agency's interpretations of its own regulations, unless the interpretation is plainly erroneous or inconsistent with the regulation's specific language they use. Not 5 years ago, in Kaiser versus Wilkie, the U.S. Supreme Court adopted a Chevron-style analysis for Auer deference questions. Kaiser is actually cited multiple times in the Loper Bright decision favorably. So the majority is saying we are still going to allow deference in certain areas. And another one would be scientific determinations by federal agencies. I think Andy's going to talk a little bit about this, but the technical expertise that these federal agencies have on scientific questions, the Supreme Court's been very clear over the years that that's left to those responsible federal agencies, and nothing in Loper Bright indicated that they were willing to come off of that. So with that, I'll hand it over to Andy.
Thanks, Jeff. So you may be thinking, why does this matter to me as a life science company or a broker or somebody else in this industry? I don't really care what a bunch of lawyers and government bureaucrats think about these things. As we've sort of been hinting at the whole time, I think there's going to be a fairly pervasive effect on the industry, not only the life science industry, but really anything that's regulated by the federal government in general. So I have on this first slide here, chaos. And I really think there's going to be chaos in two fronts, at least as I talked about it on this slide. In the beginning, it's going to be your glass half empty analysis. And then I will get to the glass half full towards the end, because I don't think this is all bad news for the life science industry. But I think you're going to see from a legal front kind of a procedural element and the substantive element. And what I mean by the procedural element is Loper Bright has been decided, and as Jeff said, it's been sent back down to the DC circuit, and now they have to figure out what the heck do they do, right? How do they put this together and figure out what this statute says about fishery or monitors on fishing boats and all that? I think you're going to see from the various circuits and the lower trial courts different ways to try to interpret what they think the Supreme Court meant by Loper Bright and its bounds and its limits and how you interpret it. Likely at some point, some of those will conflict, and then we'll be back before the Supreme Court getting a little further guidance. As Jeff mentioned in his piece there, that happened numerous times, honestly, with Chevron, and I can't see it not happening at least a little bit with Loper Bright. And then there's what I would call the more substantive element here. So what elements of the FDA essentially could be under attack with this Loper Bright analysis? I looked at Outside Resources. They're on the slide here because they're much smarter than I am on these issues, but they suggest that off-label promotion may be something that could be under attack, as well as there are certain interpretations from the FDA that historically have been used to interpret preemption, which have honestly limited the application of the doctrine. And as somebody who gets frustrated by preemption and the difficulty in having that enforced by the courts, I would be happy to have any impediments to that doctrine knocked away by the courts. Let me move on to my next slide here. Why are we not moving? There we go. All right. So this is, I guess, the second half of the glass half empty. And I just really like this quote from Justice Kagan and the dissent on Loper Bright about an alpha amino acid polymer and whether it's a protein. And as somebody who went straight from his politics and history degree into law school, if I were on the bench, somebody would have to explain to me what an alpha amino acid polymer was, let alone how it qualifies as a protein. So, you know, for you all in the life sciences industry who have these, you know, impressive engineering and scientific backgrounds, having someone who's a lawyer who probably doesn't have that background decide potentially tricky areas of the law is a little bit concerning, right? Because they just don't have the background in the science that you all do in the industry. It sort of also raises a question of how the judges are going to become educated on these. That might leave openings for expert witnesses or other folks from the industry to try to testify if this is in a lower court to figure out what this is and what it means and what the science is. So that's kind of one element to look at. And then the last section of bullet points on this slide this is kind of the politics aspect of this. And I think if you're somebody whose product touches on, for example, birth control or something of that nature that's a little more political, you might be at the mercy of advocacy groups and politics. The thing I think about in this arena is mifepristone, which the U.S. Supreme Court in the same term this year upheld the FDA's approval of mifepristone. But the whole case started a few years ago when an advocacy group found a favorable judge, I think in Amarillo, Texas, who took at that point a fairly unprecedented step of questioning the FDA's approval of the drug beginning back in 2002. So, you know, if you're making tongue depressors or something that isn't really a hot button cultural, social issue, this may not matter as much to you. But for those of you that do, you may be at the mercy of the advocacy groups here who have become much more adept at finding the judge that they need to advance their position on these issues. All right, and then the last part here, I guess I lied a little bit more on kind of the glass half empty, but there's the, can you rely on the FDA's decision? And this study that I cite here under this first section here, I believe came in and out about in September, and it looked at 26 decisions involving Loper Bright that had been decided by federal judges since Loper Bright came out from the Supreme Court earlier, like I think in June. And what's fairly shocking about this is 22 of them basically changed the government's position. Maybe it's not shocking, but it's a really high percentage, higher than I would have guessed. So you see there's been 26, 4 struck down the rules, 15 halted their enforcement, 3 rejected government requests to stay earlier injunctions. So there's a interest in really not deferring anymore like they were for the last 40 years, right? But let me end on a glass half full aspect on this. The uncertainty isn't all bad. I think for the potential of being at the mercy of outside influences, this also lets industry groups and larger companies or groups of companies challenge the things that the FDA are doing that they think are wrong or don't work for their industry. There's not the deference that was there before. So that's something to kind of keep in mind as a maybe more favorable aspect to this. And then I found this when I was looking at an AVMed article about Loper Bright, their alert, and they said, you know, Congress is going to be forced to put more of the technical aspects in their laws, and they're going to need people to help them. So this, I think, helps the lobbyists or those of you who may have an ability to advocate kind of at the law passing stage to make sure that these things are being done in a way that's that works for you in the life science industry. So Loper Bright is kind of the latest in a series of decisions by more conservative leaning advocacy groups attacking, maybe that's too strong a word, but trying to reach a different conclusion about the size of the administrative state. So the latest case out there is FCC versus Consumers Research. This may be the next Loper Bright. This involves the Federal Communications Commission program. It's called the E-rate program, where essentially taxes are collected from telecommunications companies, and then they are administered by a nonprofit set up by this E-rate program legislation to provide grants and money to smaller areas to subsidize their phone and internet. I've heard stories about this in the past where, for example, in rural Kentucky and some of these areas, it's really helped get broadband to areas that didn't have broadband before. But it was challenged by this consumer group. And I won't go through every detail on the slide here, but essentially the position is it violates what's called the non-delegation doctrine, which I think can be simply said as the government does government things. We don't contract out to nonprofits or private entities to do things which are the government's responsibility. This is something that was last used in response to the New Deal legislation in the 30s and 40s. So the Supreme Court heard argument on this recently. We'll probably get a decision, I would guess, sometime in the spring or early summer. And the expectation is the consumer group's going to prevail and the Supreme Court's going to accept this non-delegation doctrine. So I don't have a kind of apples to apples comparison here for the FDA, but it's something to keep in mind. And when I asked people who are monitoring kind of what the FDA does on a day-to-day basis, the suggestion I got is that FDA user fees may be the most similar thing that we could see an attack on, that there are folks that want to try to attack the user fees, which could be, quite frankly, problematic for the FDA since so much of their budget and their ability to operate comes from those user fees. So let me pass it back to Sonia here to talk about the acetaminophen MDL.
Thank you, Andy. So now this is the part where we get to talk about our favorite cases, the best cases we think in 2024, because this is a year-end seminar. And I picked the acetaminophen MDL. And there's a few reasons why I picked it, not the least of which is the best thing to happen to our clients in the last couple of years, I think, are the amendments to Federal Rule 702 regarding expert admissibility. And that's led to a number of terrific results, particularly in mass tort cases. The 2023 revisions to Rule 702 mainly reminded judges of their gatekeeping functions as announced in Daubert. The amendments reminded judges to strictly apply the Bradford Hill requirements for the admission of expert testimony, that the starting point for an association is observational research coupled with statistically significant results. So with that overlay, the issue in the acetaminophen cases was the ingestion of acetaminophen by the mother who allegedly while she was pregnant, which allegedly led to autism and attention deficit disorders in the offspring. The litigation snowballed quickly, and the MDL case, and an MDL court was established to hear the issues mainly involving causations. The cases were assigned to federal judges in East Cote and the Southern District of New York. Initially, Judge Cote, before the amendments, issued a couple of rulings that went against the defendants regarding causation. But ultimately, as a result of these rulings, I think, or had a large part, the Judge Cote dismissed all 5 of the plaintiff's expert witnesses. They were barred, resulting in a dismissal of about 600 or so cases. These plaintiff experts were well credentialed, but the science was terrible. The plaintiff's science ignored issues, the plaintiff's so-called science ignored issues with selection bias and relied on a single statistically significant result in a multi-endpoint study that was probably the result of random chance. Animal studies could not save the multiple epidemiological failures. The judge noted that this approach with flooding of irrelevant and confusing material was cherry-picked by the plaintiffs and ignored confounding factors, i.e. other factors that could have led to the autism and ADD diagnosis. In this case, it was very helpful that the FDA had done 5 reviews between the years 2015 and 2023 of the science and rejected the link each time. So I think that wins the acetaminophen and the amendments to Rule 702. Next slide. The amendments to Rule 702 didn't just help us in the acetaminophen. It also helped us in a couple of other cases. The Anglisa cases, the 2 main excerpts were held inadmissible on the same basis. Sprafka is a case, and that was in California, although the MDL was in Kentucky. And then it did a lot to put a death knell in the diabetes drug MDL in Kentucky, which was on appeal by the plaintiffs. So not only did it help us at the trial court level, it certainly provided ammunition for the appellate courts to give weight to the trial judge's rulings on the admissibility of these experts. And now I'm going to hand it off to you, Andy.
I think this is actually
Sorry,
Jeff.
All right, I will play the part of Andy at this point. The case that I chose to talk about is something that probably is near and dear to attorneys, and that involves heartburn, which we're all familiar with in various manners and methods. Particular, this litigation, though, is much more serious, and it involves the drug ranitidine, or Zantac, as it's been known as by the brand name. The litigation that's been going on this for several years. Essentially, well, let's do some history quickly. So, some quick background. Zantac was approved in 1983. Within 5 years, it had become the world's best-selling drug. It was had sales of around $1 billion back in 1988 per year. In today's money, that equates to close to $3 billion. After 1997, the patents expired and the generics began to hit the market. But the main rights to it were acquired in 2006 by Boehringer Ingelheim. Fast forward to 2019, and Valisure was conducting some routine testing of pharmaceutical drugs, including ranitidine. During the routine test, they detected that the ranitidine would break down into a compound known as NDMA. I'm not going to try to say it, it's very lengthy, but the bottom line is that it's a known carcinogen, and the ranitidine was breaking down into this NDMA, particularly when it was stored at out above room temperatures. The concentration would increase over time, and thus was considered to be dangerous. Interestingly, NDMA is present all throughout the environment in many manners of food, including bacon, beer, and cheese. So some of you may want to keep that in mind when you go out for a burger and beer sometime. However, this finding created some real problems, first of which FDA notified the public about it. Then they requested that it be pulled, and the lawsuit started very closely after that, including an MDL in Florida. So the allegations are fairly straightforward. The thousands of lawsuits claim that the manufacturers, Boehringer Ingelheim, some others, Pfizer, GlaxoSmithKline, Sanofi, Patheon, that they knew or should have known that the contamination would occur, that they knew of this risk, but they failed to warn either the patients or the healthcare professionals. Second, they also asserted that primarily that there was delay in the recall of the drug and or downplaying the adverse effects. As I mentioned, there have been several lawsuits. These have been across the nation with the MDL and the Southern District of Florida formed up in February of 2020. And throughout these, you have a variety of claims. So some of you have just basic consumer class action claims. You have some third-party claims, personal bodily injury cases, third-party prior claims, and then medical monitoring claims. And on the next slide, we'll talk about some of the outcomes that we're seeing here. There have been several verdicts and results of late, some good, some bad. I'm going to start at the top and the bottom here. First of all, there was a very favorable ruling in Florida within the last couple of years where the experts were kicked out of the Zantac case down there, essentially ending the MDL in many respects. That was a very lengthy decision if you want to read it, over 340 pages. Unfortunately, there's a state court proceeding in Delaware right now where the Daubert challenge was denied earlier this summer in June. But what's very interesting about that is the Delaware Supreme Court has agreed to take up that on interlocutory appeal, which is very rare, and signals that the Delaware Supreme Court might be looking to reverse some or all of that decision. There have been many settlements that have taken place earlier this year, or actually within the last couple of months. GlaxoSmithKline settled almost $80,000 for over $2 billion. They had some separate settlements in individual cases. And earlier this year, Sanofi agreed to pay $100 million to settle about 4,000 cases. However, where we often hear mostly about these big dollar settlements, similar to the opioid litigation, where you hear about big settlements, which you may not hear about because they don't make the news as much, is the defense wins. In that case, I pointed out already the good decision with regards to the experts in Florida. However, there was a trial just this past month that deadlocked and mistrialed in California against Boehringer. The deadlocking was on the causation, but on the bad side, the jury did find that the drug Zantac was dangerous and that there was a failure to warn on the part of Boehringer. But because the jury couldn't decide causation, the case was declared a mistrial. There's also been mistrials in the Illinois cases against Boehringer. And in fact, even some of the plaintiff's attorneys' websites that track these, as you could probably find them on the internet pretty quickly, they've even admitted that I don't believe they've had a win in a plaintiff's case, at least this year. So there are some very solid results coming on from the defense side if these do get into court. But again, the nature of these cases sometimes has led them to be settled. So that's the one that I thought was noteworthy. And I think it's Andy now, correct?
Nope, still not me. It's Lauren this time.
I apologize. It's
Yeah.
Lauren.
So now I'm going to take the role of Andy, and we're going to talk about a noteworthy case and decisions, but maybe not something that we're all very excited about. And this is really about the newly imposed duty to innovate for those who do business in the state of California. So for a little bit of a background, Gilead Life Sciences is the pharmaceutical manufacturer here. They also run clinical trials. They do a number of different things that have been around for a very long time. The products that are involved that we're talking about are TDF and TAF. And these products really, the research into them happened a very long time ago. TDF was actually approved by the FDA for use in 2001. And around that same time, TAF was starting to be studied in human clinical trials. In 2001 or in 2004, the studies for the trials for TAF were stopped. And the reason the company gives is because they were trying to then look for combination therapies with TDF in order to help support the patient population, since these products are used for treating HIV and hepatitis B. Fast forward 15 years almost, in 2018, litigation first ensued. They had 24,000 plaintiffs who took TDF to treat HIV. And these known side effects that they suffered include bone, kidney, and tooth injuries. But the plaintiffs weren't saying that TDF was was defective. They didn't say that that there's a manufacturing issue or a design issue. They weren't saying any of that kind of thing. What they were saying was they pursued cases under theories of negligence, and California's general duty of care they have that says that you had these two products that you had that were available, that could have been available. TAF is better for the client population and should have come to market sooner. And as a result, you know, we had patients were injured because they were receiving TDF instead of TAF, even though both products eventually were approved by the FDA. This is not something that is typical or seen anywhere. It's very innovative just as a theory in and of itself, and really has to do with the ability and the rules in California, which I'm sure we're all very surprised, maybe not really, to see. So what happened as the litigation ensued, eventually Gilead tried to file a motion for summary judgment saying that there's no duty because the product was not defective. However, the trial court denied the motion, and so, you know, Gilead then appealed it on the same basis, and the Court of Appeals affirmed the trial court's decision. So next slide. So the appellate court actually concluded that the legal duty of a manufacturer to exercise reasonable care can extend beyond the duty to not market a defective product. So just because you have something that works doesn't mean that you're not liable for injuries that could happen because there's something that could be better out there. And in response, in this past May, which is why it's on the list, Gilead petitioned the court in the Supreme Court of California to review the case. And since then, 26 separate amicus briefs have been filed. And these amicus briefs are being filed by various industry, patient advocacy, and other legal groups that are concerned that this new duty in California is going to disrupt California law. It'll conflict with the FDA's drug approval regime, and they think it's going to discourage scientific innovations. So if not overturned, and at the same time, briefs have been filed, but we don't have an anticipated date as to when we should expect a decision at this point. So if not overturned, the Court of Appeals decision could have widespread and negative ramifications across all fields of innovation and manufacturing, not just the life sciences industry. It can disincentivize innovation and discourage manufacturers from investigating and develop ways to improve products. And as with Gilead's early research into TAF, this work can form the basis for lawsuits for targeting their earlier non-defective products. So this whole idea can extend not just to life sciences companies, but everyday product manufacturers, which is what makes this so important. If the California Supreme Court then affirms the lower court's decision, this new liability rule can undermine the ways in which companies then develop products, and actually discourage them from making new ones. And if we have seen anything about how laws develop, it will be interesting to see if the Supreme Court upholds the ruling, how that trickles into the rest of the United States and the rest of our legal system. So now I'm going to turn it over to Andy to talk about the Apex Doctrine.
Thanks, Lauren. I feel like after all those missed transitions to me, you guys are going to be kind of disappointed by my topic, but let's get into it quickly. So you may be asking, what is the Apex Doctrine? And the best way to explain it is to kind of go through the history a little bit. So the doctrine originates out of a products liability case in the 1980s involving the deposition of Chrysler CEO Lee Iacocca. The products case involved an allegedly defective design to the fuel system on a 1975 Dodge van. And so the plaintiff's attorneys, this is actually true, read his biography and said, there's stuff in here that's relevant to our claims. We need to have a deposition of Mr. Iacocca. The District of Rhode Island was not so convinced that this was a meritorious discovery attempt. And so the quote here kind of frames what the Apex Doctrine is. For CEOs, presidents of companies, kind of the head, they're singularly unique and important individuals, can be easily subjected to harassment and abuse. So because of this, the court said, you can't depose Mr. Iacocca. There's other ways of getting this information. In the papers, the Chrysler's attorney said he doesn't know what they're talking about. He doesn't have any knowledge of these alleged things that are relevant to the case. So in some respects, I feel like the original Apex Doctrine case is a very 1980s thing in terms of kind of its deference to the corporation and the CEOs. And as you may be able to predict with the more anti-corporate bias we see in courts today, the Apex Doctrine really just isn't as strong as it used to be. So this has led to kind of a few different approaches to dealing with it. So this slide covers what I would call the two poles on the issue. The one pole being, let's get rid of the Apex Doctrine. We don't need this. For those of you that have been to these before and follow case law, you will not be surprised that Washington is the state that decided we don't need the Apex Doctrine. Everyone has equal access or right in the court system. So if Mr. Iacocca or someone like him needed to be protected from a deposition, we have rules that cover this. There's several states with similar decisions. And then there's a quote I put in here that's sort of this one group of people saying, we don't need the Apex Doctrine. This is sort of a relic in our modern world. Then you have the other pole of saying, we're going to take this out of case law and put it in our state statutes or state court rules. Georgia actually did this recently after Georgia Supreme Court was trying to follow this Washington rationale. The legislature came back and said, yeah, no, we're not getting rid of the Apex Doctrine. We're going to put this in our the Georgia Code. Really, the majority of states have fallen somewhere in between. And this is why I think it's something you need to know. If you're an executive, if you're CEO of your company, you don't really have this absolute immunity that maybe you would have had 30 or 40 years ago, but your deposition is not a guarantee. And it's generally courts are making it a more fact-based inquiry and asking the party asking for the deposition to say, why do you need this? What do they know that somebody else doesn't know? And is there an easier way to get this, right? Can this be taken from a deposition of the executive vice president that was also in the room during the important decision that you're talking about in your case? Can we do it through a written discovery? And what's interesting is this has led to contrary results for the same people. Mark Zuckerberg was still able to apply the Apex Doctrine in a case in 2022. And then in a lawsuit this year related to his AI model, he was required to be deposed. So if there's a takeaway here for kind of the industry, it's no, you can be deposed if you're CEO or a president of your company. And I'm hoping that you're doing this anyway, but act in a way that you feel like you're going to be able to defend your actions if you're deposed. And also know that there still are protections in most jurisdictions to prevent sort of the harassment aspect of this. So that was the last case. And now we're on to our last issue, which is our crystal ball. And I'll go ahead and start off on this. And I thought I'd leave this up because really everybody's point is going to kind of get to this issue of a little bit of uncertainty. But I wanted to start with attacks on baby food, baby formula, which seems to be kind of a potential target of the plaintiff's bar these days. So two things to kind of highlight for you. There has been a number of cases filed against Abbott regarding its Enfamil baby formula, and this is a formula that's used for extremely premature infants. Some of them are born as early as, I believe, about 6 months. And the formula is derived from cow's milk. And for premature infants of that age, the cow's milk can allegedly cause something called necrotizing enterocolitis, which is as bad as it sounds. It's a pretty horrible disease where essentially it destroys the intestines, and it can be fatal. So there's 1,000 of these lawsuits. A couple of them, 3 of them really have been tried this year. The first one resulted in a $60 million verdict in Illinois. Over the summer, there was a $495 million verdict in one of our favorite places, St. Louis, which included a $400 million punitives award. And then, interestingly enough, also out of St. Louis in November, there was a defense verdict. So I expect that Abbott is probably, based upon that recent result, they may try some more of these and then see if they can get rid of these lawsuits. Back after that $495 million verdict, Abbott was telling investors they may pull the product from the market because the exposure is basically greater than the amount of money they make off of the product. The second is a MDL that was started earlier this year. It's based in San Francisco, and it says that certain baby foods contain heavy metals, which have led to brain injuries resulting in autism. So I feel like we just got out of the acetaminophen and autism MDL, and this seems to be the latest in that world. It involves some fairly large baby food companies, including Beechnut, Gerber, Earth's Best Organic, Walmart, Sprout Foods. There's 75 pending lawsuits from what I could decipher. I saw one law firm that claimed it had over 3,000 plaintiffs. These really haven't gotten that far yet. There have been some basic motions to dismiss and things of that nature. But I think that MDL may be picking up steam in 2025 and may be sort of the tip of an iceberg of decisions and MDLs relating to these infant and baby products. So that's all I have, and I believe I turn it over to Lauren now.
You do. Hi, this is Andy again. You're welcome. So I think what we're going to see in 2025 is more information and possibly decisions regarding litigation financing. It's definitely been a hot topic over the last couple of years, and more recently there have been articles that have come out about the effect of litigation financing on plaintiff attorneys in mass torts when the mass torts don't resolve within 5 years within the time that the contracts come due. There have also been a couple of decisions more recently about whether the presence of litigation financing or not should be discoverable on the plaintiff side, given insurance information is discoverable on the defense side for personal injury cases. So I think that those are things to watch out for and to see, because it really does change the dynamic of a case when one side, either side, both sides have additional means in order to push the case further along, in order to try to get a better result for themselves. And now I think, Jeff, you're next.
My uncertainty comes is focused on the federal courts and how they're going to approach their job with several of these streams we've talked about today. We talked about Loper Bright and the removal of the Chevron analysis and the deference requirement, but there are still forms of deference allowed. I think there's going to be some uncertainty in how the federal courts go about some of those deferential standards under Skidmore and Auer. I think you're going to see some similar strains of the court having to come back and Loper Bright to maybe offer some clarification at some point. But some of that uncertainty also comes from the fact of how the judges are going to approach doing their ultimate job. And right now, what we're seeing from the highest level is an increasing reticence to allow executive branch agencies to assume core judicial functions and responsibilities. We see that in Loper Bright. Interestingly, the day before Loper Bright, the U.S. Supreme Court put out a case called SEC versus Jarkissi, which found a 7th Amendment violation of statute allowing the SEC to seek civil penalties, but that was done before an administrative law judge. And it was found to have violated the right to a jury trial that was available to them. So in other words, this was a similar case saying that the courts have functions and they need to do them. Sonia has already mentioned the Rule 702 amendments, where they took away the weight non-admissibility fallback that the judges would often rely on to say, we're going to allow the expert to testify. So the judges are being instructed to do heavy lifting. Mixing into that uncertainty, we're now in a regnum between judicial selections. We had 4 years of Trump selecting judges, and we had 4 years of President Biden selecting judges, each getting a similar number. There's a pending law right now, the Judges Act of 2024, which proposes to add 63 new federal judgeships to be filled over the next decade. While it has bipartisan support, President Biden has indicated that he is unlikely to sign that bill. In fact, he said it would veto it. And on top of that, President Trump will get to fill some new appointments coming up. But I was in the room recently with someone who was involved in the selection process in the first 4 years, and he believes they'll only get to select about 50% of the judges they did previously, not numerically. So I think you're going to see some uncertainty in how the judges go about their job, but also wrestling with this new paradigm where they have to do some very heavy lifting.
All right, so I'm the last at bat, and I'm not going to focus on uncertainty. I'm going to be my usual Pollyanna self and be positive. I think one of the things that we're going to see is the use of AI across multiple areas. And I think the use of AI is going to be a game changer, especially when it comes to detecting fraud and inconsistent results in the clinical trials. Spent a lot of time talking about problems with clinical trials in China and India. AI can be used to detect fraud by analyzing vast amounts of patient data to identify unusual patterns, inconsistencies, or anomalies that might indicate data manipulation, such as fabricated results, missing data, or other values, allowing for early detection of potential fraudulent activity during a trial. So I think there's a lot of interesting uses to AI, but they could actually be used in a very positive way with respect to clinical trials. And I think that's it. I'm sorry we went over our time. We may have time for maybe 1 or 2 questions.
I think where we're past the hour, we can wrap up. We wanted to thank you all very much for your time today. This is always a popular presentation, and there was so much information for the audience this year. I know this will be a valuable resource for them.